but here we go. The state's response opposing a motion for evidentiary hearing post-conviction relief under Wisconsin Statute 97406. Defendant Stephen Avery, Mr. Avery, by his undersigned attorneys Kathleen King Zellner and Associates and Stephen G. Richards, for his reply to the state's response in opposition to his motion for evidentiary hearing and post-conviction relief, states as follows. Introduction. The state has presented an argument designed to obfuscate the significance of Mr. Avery's powerful new evidence that Bobby Dassey and that the opportunity and the directly connected to actually murdering Teresa Halbach and planting the forensic evidence to frame Mr. Avery because he was observed pushing her vehicle, which contained her blood spattered in the rear cargo area and door, onto the Avery's salvage yard in the middle of the night, planting it where it would easily be discovered the next day. The RAV4 contained evidence of a violence inflicted on Miss Halbach, her clothing and personal effects, blood, and the forensic evidence that was used to convict Bobby's uncle, Mr. Avery, of Miss Halbach's murder. Bobby's possession of the RAV4, with Miss Halbach's blood splattered inside of it, demonstrates he's not only had a direct connection and opportunity to murder Miss Halbach, but also to plant the following evidence contained in the vehicle. Miss Halbach's 3 electronic devices were burned and placed in Mr. Avery's burn barrel, the license plate that was removed and hidden in a salvage car, Mr. Avery's blood that was found carefully dripped in the front of the seat of the RAV4 and applied to the dash with the applicator. Spelling of a flammable liquid. Investigators admitted in their report that they utilized the Woods light to eliminate any secretions on Stephen's body. Fritz subsequently took 2 swabs in Stephen's groin area. After that, she continued and was going to take some more swabs with Special Agent Fassbender, and Uyghur conferred and determined that the search warrant did not call for that type of exam. Mr. Avery has previously argued and presented evidence that one of the 2 swabs was kept and deceptively submitted to the Wisconsin State Crime Lab. Uyghur as a RAV4 hood latch swab, which contained Mr. Avery's DNA. Mr. Avery's trace expert, Dr. Christopher Palaniuk, opined, after conducting a series of experiments in the alleged blood latch, the hood latch swab never swabbed the hood latch. The state argued at trial that Mr. Avery's DNA was deposited on the hood latch when he opened the hood with sweaty hands and disconnected the battery to prevent the vehicle alarm from being activated. The state's theory is implausible at best. Mr. Avery's fingerprints were not found anywhere in the RAV4, even though the state fingerprint expert found the latent prints on the vehicle and testified that someone with sweaty hands was more likely to leave prints than someone with dry hands. The killer had Miss Halbach's keys, so the chances of triggering the alarm were remote at best, and even if that had occurred, the alarm could have been quickly disabled by using the key. Mr. Avery's new witness, Thomas Sawinski, provides the plausible answer as to why the battery was disconnected when he describes the RAV4 lights being off when he observed Bobby and another individual pushing the vehicle onto Avery's salvage yard. Clearly, the obvious and simple explanation of the battery being disconnected was to disable the vehicle's interior and exterior lights so that Bobby and his unidentified companion could push the vehicle onto the Avery salvage yard and avoid detection. Mr. Avery never deposited his DNA on the RAV4 hood latch. The state never explains why Mr. Avery's DNA is not found in the vehicle but is found on the hood latch, or why his blood is not found on the hood latch but is found in the vehicle. Of course, his fingerprints are found nowhere in the exterior or interior of the vehicle. Bobby, by his possession of the RAV4, is directly connected to both Miss Halbach's murder and the framing of Mr. Avery. Bobby's possession of Miss Halbach's vehicle gave him the opportunity to murder her and plant forensic evidence used to frame Mr. Avery. Epical case law. I'm not going to read all these footnotes. Argument. Mr. Avery had pled sufficient facts to meet the prongs of the Denny test. The appellate court found that Mr. Avery's new evidence could establish a direct connection between Bobby and the murder of Mrs. Halbach, making him a viable Denny suspect, specifically, appellate court stated. As discussed below, we are now addressing Mr. Avery's most recent filing to this court. Our discussion of motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin Statute 97406 motion That motion would need to survive both escalating and natural scrutiny and be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the VLCD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merits of such 97406. All such issues would be for the circuit court to decide in the first instance. The state's motive argument. The state devotes 36%, 14 of 38 pages, of its entire argument to motive, which is the least important of three prongs of Denny in this case, because Mr. Avery's new evidence of the direct connection of Bobby to the actual commission of the murder and planting of evidence to frame Mr. Avery. Another 15% of the state's argument, 6 of 38 pages, is devoted to opportunity prong. A mere 6.5%, 2.5 pages of 38, is devoted to Mr. Avery's powerful new evidence of Bobby's direct connection to Ms. Halbach's murder and the planting forensic evidence in the frame of Mr. Avery. As stated in the introduction, the state's allocation of the argument in 3 Denny prongs to minimize direct connection and opportunity evidence is deliberate strategy to distract, mislead, obfuscate, and fact that evidentiary must be held because Mr. Avery has overcome the procedural bars and met the specific requirements to proceed to a hearing on his new evidence and Brady violations. As part of the obfuscation strategy, the state attempts to impose an impossible burden on Mr. Avery, not required by state case law, Wisconsin case law, to provide the substantial certainty that Bobby had the motive to murder Ms. Halbach, because motive is never an element of any crime. The state never needs to prove motive. Relevant evidence of motive is generally admissible. The same applies to evidence of the third party's motive, the defendant in Ms. Halbach's murder, and the framing of Mr. Avery. Mr. Avery's motive evidence is relevant regardless of the weight assigned to it by this court. The state does not dispute that viewing violent pornography could establish motive for a murder. Rather, the state claims that Dassey's pornography of young females being tortured, mutilated, and otherwise abused is simply too mundane, too vanilla, too boring to propose someone to commit a murder. The state opines an expert without having a real expert on violent pornography, and these searches where images of abuse and deceased young females are simply too dull and generic for concern. The state, in an effort to divert attention from the powerful new evidence, the opportunity and direct connection of Bobby to the murder of Ms. Halbach, planting of evidence, claims that Mr. Avery has failed to prove motive by failing to identify with substantial certainty that the individual who performed these thousands of pornographic searches on the Dassey computer, as if the burden of proof requires Mr. Avery to produce a videotape of Bobby performing these searches. The state is imposing a burden of proof for a motive that does not exist in Wisconsin law. The issue is whether the pornographic searches of the Dassey computer are relevant to the motive regardless of the weight of the motive of evidence. The state's strategy fails to consider the new witnesses as established opportunity and a direct connection between Bobby and the murder of Ms. Halbach and the framing of Mr. Avery. As the appellate court found, if the new direct connection evidence survives scrutiny, the motive evidence found in the VLCD might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. The state wants the court to believe that because some of the computer searches could be done by someone else, Mr. Avery's Denny argument fails. What the state conveniently overlooks is that no one else from the Dassey household has been identified as having possession of Ms. Halbach's vehicle after her disappearance. Mr. Avery's motive evidence must be evaluated in the light of his powerful new evidence and direct connection of the opportunity for Bobby to be perpetrator of this crime and the one who framed Mr. Avery. No right lines can be drawn as to what constitutes a third-party direct connection to a crime. Rather, circuit courts must assess the proffered evidence in conjunction with all the evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third-party perpetrator actually committed the crime. Additionally, in its response, the state ignores well-established Wisconsin case law that the court must assume that the facts in the pleading to the jury would determine legal sufficiency of the pleading. As juncture, this court must assume that Bobby was the primary user of the computer, as his brother Blaine has attested in an affidavit. and therefore it is highly likely that Bobby was conducting the searches for pornography. Also, Bobby has been caught in a blatant lie about the location of the computer. He told the police the computer was located in the living room, when the crime scene footage showed the computer was located in his bedroom. Regardless of the dates and times of the searches, Bobby cannot be ruled out by the state, and an individual who is conducting any of the searches for pornography and his motive must be evaluated in light of possession of Ms. Halbach's vehicle, which establishes a direct connection and opportunity to commit the actual murder of Ms. Halbach and to plant the forensic evidence. The appellate court correctly noted that Mr. Avery cannot definitively prove that Bobby's schedule by relying on the affidavits of his computer expert, Gary Hunt. Mr. Avery has added additional evidence, including the affidavit of Blaine Dassey and police interviews regarding the family members' schedules. Importantly, the motive evidence has to be reevaluated in the light of the new evidence of the direct connection and opportunity of Bobby to have actually committed the murder and planted evidence against Mr. Avery. The appellate court did not consider this new evidence, ruling as follows: this is instead a distinct issue that the circuit court should resolve as standalone basis in the new Wisconsin statute. The state claims in response to the Avery's contention that law enforcement considered pornography as evidence of motive is false. The hypocrisy of the state's argument is vividly illustrated by the fact that on March 10, 2006, the state filed an amended information against Mr. Avery, adding that the charge of sexual assault, among others. The amended charge would result in Brendan Dassey's confession on March 1st, 2006. The only plausible reason law enforcement spent substantial time after April 21st, 2006 seizure of the Dassey computer, collecting and analyzing the pornography on the computer, was to corroborate Brendan's confession by establishing a sexual assault motive from Ms. Halbach's murder. The state's electronic data investigator, Detective Veely, created word searches relevant to the murder and attempted to connect these specific words to the contents of the Dassey computer. Significantly, Mr. Avery's trailer has a computer where also searched extensively for pornography and none was found. Detective Veely was asked to generate a report of Mr. Avery's computer. Based on Veely's report, no apparent searches of pornography and or sexual images were made, and no websites or apparent sexual or pornography images were accessed. The clear working theory of the investigators was that the murder of Ms. Halbach was motivated by sexual assault and described in Brendan's confession. Other motives were ruled out, such as robbery, animus against Ms. Halbach, who had no known enemies. In Judge Willis's January 25, 2010 order denying Mr. Avery's post-conviction relief, Judge Willis explained that while neither the state nor the defense was able to offer any direct connection of motive for Stephen Avery or anyone else to have wanted to murder Teresa Halbach, it is not fair to say that either the party regarded their murder as motiveless crime. Clearly, there was a motive for Ms. Halbach's murder. Sexual assault is a frequent motive in murder of young women. There are clearly established correlation between compulsively and obsessively viewing pornography and sexual assault. Mr. Avery's expert on sexual homicide, Ann Burgess, opines in her affidavit, relying upon 30 years of empirical research, that there is well-established causal connection between pornography consumption and violent behaviors. In paragraph 51 of Mr. Avery's third motion for post-conviction relief, Mr. Avery supports his argument with Dr. Burgess' opinion that the state in its response completely ignores or overlooks the expert opinion of Dr. Burgess, who provided expert deposition testimony in Wisconsin Premise liability sexual assault case in Kenosha, Wisconsin. The state ignores Dr. Burgess' qualifications and publications. Dr. Burgess has been qualified as an expert in areas of child pornography, crime classification, offender typology, rape victims, rape trauma, serial offenders. She was published successfully, including co-authoring 24 books, 30 book chapters, and over 164 pre-reviewed articles. She has co-authored the book Sexual Homicide Patterns and Motivations, a Criminal Classification Manual, Understanding Violence Against Women, Violence Through the Forensic Lens, and Forensic Science Lab Manual, co-authored with two FBI agents, John Douglas and Robert Ressler. Because the state charged Mr. Avery with sexual assault on March 10, 2006, the DAS computer was seized by law enforcement on April 21st, 2006. Law enforcement made great efforts to extract all the pornography from the DAS computer, even went so far as to have Detective Veely conduct specific word searches related to the murder in an effort to connect the pornography to the murder. The Veely CD contains states recovered pornography images relevant to the material to Hallbach's murder on the CD. Detective Veely refined 14,099 images of them DVDs and recovered 1,600. DVDs contain thousands of images of violent pornography, criteria, word searches, registry, internet history, Windows history, and all the MSN messages, all of which revealed proximity of sexual violence. There were 2,632 word searches performed by Detective Veely of words that believed were directly related to the crime, including blood, body, bondage, bullet, cement, DNA, fire, gas, gun, handcuff, journal, rab, stab, throat, and tires. In the response, the state only refers to Detective Veely's word searches for news, body, journal, and cement, leaving out the other searches for distinguishedly claiming that the mere fact that someone searched news, body, journal, cement doesn't show anything similar to related to the crime. The state claims that Mr. Avery gives no explanation for how any of the search terms are relevant to the individual's motive for this murder. However, the state chooses these few cherry-picked words and ignores the rest to minimize the importance of the word searches. Taking these terms in context of Miss Hallbach's murder and potential motive, all these terms are relevant. 2 bullets from a gun pierced her skull. There was a fire ignited by gas and tires which burned her body. She may have been handcuffed. She bled in her vehicle, so she had been stabbed. Her DNA was found on a bullet, and she did keep a journal. In response, the state concedes that Bobby is the least connected to the 3 of the most violent searches prior to Ms. Hallbach's murder, but the state has inadvertently conceded that Bobby is connected to 25 of the searches after Ms. Hallbach's murder. More importantly, Bobby cannot be eliminated by the state from any of the pornography searches, especially the ones conducted prior to and very close in time to Ms. Hallbach's murder. The individual performing the searches was becoming especially deviant in the weeks before Ms. Hallbach's murder. The state, in response, incorrectly regards that McCary does not have credentials of opine, the police procedure expert. As the court noted, McCary has the following credentials. McCary is professional involved in violent crime, investigation, crime scene analysis for more than 40 years, including 25 years at the FBI. While at the FBI, Agent McCary investigated violent crimes as field agent approximately 17 years, after which he was promoted to supervisory special agent and transferred to the FBI Academy in Quantico, Virginia, as supervisor special agent. McCary worked at the National Center for Analysis and Violent Crime and operational wing of the Behavioral Science Unit. Agent McCary's primary responsibility as supervisory special agent was to provide expertise in investigation techniques and crime scene analysis and violent crime investigations, both the FBI and field agents and the law enforcement agency that requested FBI assistance. His other responsibilities included conducting research into violent and sexual violent crime, providing training to law enforcement agencies nationally and internationally. Blah, 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 blah. All the evidence appeared to point to Bobby conducting the searches in question on weekdays, but it is necessary to have evidentiary hearing to definitely determine if it was him. Based upon the findings of Mr. Gary Hunt, 667 sexual content searches were performed in total. Of those searches, 562 were performed on 10 weekdays between 6 a.m. and 3:30 p.m. 8/16/2005, 4 searches. 9/13/2005, 12 searches. 2/23/2005, 48 searches. 3/29/2006, 37 searches. 37 searches. 3/30/2006, 23 searches. 4/3/2006, 93 searches. 4/5/2006, 96 searches on 4/6/2006, 14 searches on 4/13, 39 searches on 4/19, and 196 searches that date. Therefore, 64 sexual content searches were performed prior to Ms. Halbach's murder between 6 a.m. and 9 a.m. 28 searches for terms describing violent accidents, specifically violent car crashes, with images of dead bodies. 13 searches for terms describing drowned, dead, or deceased female bodies, and 65 searches for terms describing the infliction of violence on females, including fisting and images of females in pain. The state links Bobby to 28 of these searches during the day and argues that only 3 of those 28 are relevant because they occurred before Ms. Halbach's murder. However, the state totally misses the point that all 677 sexual searches are relevant to a sexual assault motive, which would exist before the crime and corroborated after the crime by continuing obsessive pornography consumption. Mr. Avery has provided sufficient evidence concerning the schedules of the occupants of the Dacia residence to justify an evidentiary hearing on the issue of who was conducting the searches. Mr. Avery was provided additional evidence from the provided to his appeal about the schedule of the occupants of the Dacia residence, showing that the pornographic searches primarily occurred on weekdays when Bobby was thought to be in the residence. To make determination, the evidentiary hearing must be held. Stated differently, in the absence of the evidentiary hearing, it's impossible to make this determination. The schedules of the other Dassey's household members seem to eliminate them from the search cited above. Barb's work schedule was from 6 to 4:30 every day, Monday through Thursday of every week. Brendan and Blaine would get picked up by the school bus at Avery Road between 7:08 and 7:13 a.m. and dropped off at the same place where between 3:30 and 4 p.m. Therefore, it appears that Barb, Blaine, and Brendan, the 3 other individuals living at the Dassey residence, are excluded from being present, much less having access to the Dassey computer. At the times many of the pornographic searches occurred, additionally, Brendan would have been eliminated from all but 26 of the 128 of the most violent searches related to Ms. Halbach's murder. 20.3% have been arrested on March 1st, 2006. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have the password for the computer, nor did he possess a key to the Dassey residence, which was locked when no one was home. Mr. Avery only entered the residence with permission of the Dassey family members. Mr. Avery worked during the weekdays from 8 to 5. Mr. Avery would be eliminated from all but 15 of the 128 of the most violent searches related to Ms. Halbach's murder. 11.7% simply by having been arrested on November 9th, 2005. The searches that took place after Ms. Halbach's murder, the state argued after Avery fails to explain how motive to fulfill a violent porn-fueled sexual fantasy can be performed or proven by someone not viewing any of this material until months after the murder already occurred. However, crime, and a legitimate subject to consideration as bearing upon the probability of his guilt, motive can manifest itself after the crime when the perpetrator is revealing and fantasizing about the crime. The continued searches for pornography demonstrate that the motive for this murder was a sexual assault. It is highly significant that the searches for deceased, mutilated young women began after, not before the murder, but mutilation of Ms. Halbach. The searches after the murder coincided with the fact that young woman was murdered and mutilated. The searches before the murder coincided with thousands of images of young women engaging in sexual activity, many unwilling and corroborated a sexual assault motive. The Dassey computer deletions and constitutes the guilt of interference. The state completely ignores the evidence presented by Mr. Avery of the Dassey computer deletions, which infers constitutes of guilt. Significantly, many of the Dassey computer searches have been deleted, and only some of them were recovered, which leads to the question of who in the Dassey household deleted the searches and why were these searches deleted before Mr. Avery's trial. To make a complete and thorough record of who made these searches, why those searches were made, and who deleted the specific searches, there must be an evidentiary hearing that consists of the testimony from the occupants of the Dassey household who can answer these questions for the court. It is not possible for the court to determine without the evidentiary hearing who conducted the searches of the pornography and who attempted to delete the pornography after the murder of Ms. Halbach and before the trial of Mr. Avery. It is highly significant that the investigation, if there is an attempt to delete or destroy records in this sexual assault case, the Illinois court found constitutive guilt was also evidence, as he told the victim to delete the text messages had exchanged. The appellate court found the fact that the jury heard evidence from which it could infer that Mercer deleted the files with his forensic examiners would have found the child pornography stored in his hard drive was significant evidence to determine the defendant's guilt. Mr. Hunt was identified 8 times when there was deletions on the Dassey computer. Those deletions are very important because they correlate the Miss Halbach visits the property. Miss Halbach visited the property on August 22nd, and there are deletions on the Dassey computer on August 23rd. August 26th, Miss Halbach visited the property. On August 29th, there are deletions from August 28th, 2005 through September 11th, 2005. Ms. Halbach visited the property on September 19th, and there are deletions from September 14th through September 15th. There are also deletions from September 24th through October 24th, 2005. Most significantly, around the time of her murder on October 31st, 2005, there were deletions from October 26th to November 2nd, 2005. During the investigation of Ms. Halbach's murder beginning on November 3rd, there were further deletions made on the Dassey computer. These deletions at the above described relevant times cannot simply be dismissed as mere coincidences. An evidentiary hearing needs to be held to determine who made these deletions and why. Dr. Burgess wrote in the affidavit, "It's not unusual for an organized offender to try to cover up his fantasies by deleting files from a computer." She agreed that Mr. McCary that it is highly significant that any investigation if there's an attempt to delete destroyed records. Dr. Burgess concluded the following. The offender in the Halbach murder would be classified as an organized offender who plans, thinks things through, and tries to cover his tracks by deleting incriminating files, interjecting himself into the investigation as a primary witness for the state, misleading investigators about the timeline and events surrounding the murder, and would be very likely to attempt to plant evidence and frame another for the murder. The offender would keep secret his commission in the sadistic murder of Ms. Halbach. The state attempts to distinguish from Dressler and McCarthy, a case that Mr. Avery cited for support, arguing the first that Dressler, there is no dispute that the other two are so strong. Dressler motivated evidence established by the defendant's pornography collection. Opportunity was established by the simple fact that the victim visited the defendant's neighborhood. Here, Bobby's possession of the sin by establishing Bobby's direct connection to the crime. An opportunity to have committed the murder and planted evidence to frame Mr. Avery. The state argues that Bobby's searches did not reveal things closely mirroring the crime, contending Avery fails to point a single image of search for someone who was shot and body burned, nor anything would suggest that they're widely, and has included such relevant and off-point searches as MySpace, tires, race car accident, Ford Focus accident, deceased girls, and big women naked. The state is wrong. Mr. Avery did in fact provide the court with specific searches about someone who was shot and searches for a gun into the head. There were 8 searches prior to Ms. Halbach's murder and violence were offered to prove Dressler's fascination with death and mutilation, and this trait is undeniable probative to the motive, intent, or plan to commit a vicious murder. Likewise, here, most of the Dassey computer pornography consists of images depicting violence, even a race car accident that show a fascinated with death and the mutilation, and this trait of Dassey's pornography consumer is undeniably probative for the motive, intent, or plan to commit a vicious murder. Moreover, each piece of defendant's offered of evidence need to eventually satisfy all 3 prongs of the Denny test. Some evidence provides foundation for other evidence. Facts give meaning to other facts, and certain pieces of evidence become significant any criteria that would stand alone. The state's opportunity any criteria that would stand alone. The state's opportunity argument. According to the trial court, Mr. Avery's trial defense counsel already established that Bobby had the opportunity to commit the murder of Ms. Halbach by his mere presence at the Avery salvage yard on October 31st. Now the state wants to place an additional burden on Mr. Avery, relying on Kansas and not Wisconsin case law. The state admits that under Wisconsin law, opportunity can be established by simply showing the third party who was at the crime scene. However, the state contends that in order to meet the opportunity prong, Mr. Avery has to offer evidence that alleged third-party perpetrator had the skills, contacts, tools, time, and other means necessary to have committed the crime and staged the scene in the matter of defendant alleges. Opinion. There is no such requirement in Wisconsin law which states in much general terms that sufficient to demonstrate evidence that a third party had realistic ability to engineer such a scenario. The state concludes that Mr. Avery's submission does not meet the Kansas standard. Since Mr. Avery's case is pending in Wisconsin, he is focused on his submission meeting the Wisconsin standard, which has clearly accomplished. The state is baffled by Bobby, who wants to frame Avery. The answer is simple. If Mr. Avery was not prosecuted for Ms. Halbach's murder, then Bobby was the next most likely candidate to be prosecuted for her murder, as he was present and observing Ms. Halbach during her visit to the Avery property on October 31st, 2005. Bobby lied about being asleep from 6:30 to 2:30. Searches were made on the desk computer at 7 a.m., 9:33, 10:09, 1:08, 1:51. Prior to Ms. Halbach's arrival at the Avery salvage yard, Bobby was the only one home during these searches, according to his trial testimony. Bobby was present and awake when Ms. Halbach called and left a voicemail requesting the exact address of the appointment. He was present when Ms. Halbach arrived. He lied about Ms. Halbach walking toward Mr. Avery's trailer because he saw her leave the property at the same time he left the property. He lied about going hunting and passing Scott Tadich at 3 p.m., going to East on the Blazer when he was seen at 3:30 p.m. driving an unknown vehicle west by his brother Blaine and a propane driver on Avery property, which resembled Ms. Halbach's vehicle. Ms. Halbach's RAV4 was seen by witnesses parked at the turnaround about 1.8 miles west of the Avery salvage yard in the direction Blaine saw Bobby driving. Bobby had human fingernail scratches on his back, and he claimed they were from his puppy. Bobby gave false testimony about Mr. Avery's alleged remark about disposing of the body. This remark was completely disrespected and contradicted by Michael Osmondson. Spelled his name wrong. Combined reports of re-interviews of Bobby, where Bobby never told this to law enforcement. Ms. Halbach, fuel-stained, cut large bones were found in Dassey burn barrel, including the scapula, portion of the spinal column, macrophages, fragments of lung bones. State argues that Avery's defense theory has changed dramatically since the trial. However, the state fails to acknowledge that because the trial court barred the introduction of a third party, Mr. Avery's trial, obviously prior to the discovery of violent searches of Sawinski's evidence, Mr. Avery's trial defense counsel did not have the ability to suggest that persons other than law enforcement officers had access to bloody bandages, blood towels, and blood drips that came from Mr. Avery's pre-existing finger injury. It is in response to the state claims that Avery offers. Nor has Avery explained why someone who wanted to frame him would go to such lengths to hide the evidence. Surely if Bobby or anyone else wanted to frame Avery, they would have gone to their way to make all the evidence difficult for law enforcement to detect, gather, and connect to Avery. The state claims that by hiding the RAV4 on the Avery property, it led to authorities right to the Dassey's door. The state assertion is demonstrated false, putting the RAV4 on the Avery property with Mr. Avery's blood in it and led the police directly to Mr. Avery's door. The RAV4 was not carefully hidden because the civilian search found it in less than 35 minutes among hundreds of salvage cars. It makes perfect sense, contrary to the state's argument, that the burn and the victim's remains personally property and plant them in Mr. Avery's burn pit and then frame him. Mr. Avery was the only one who had a huge civil rights case pending against Manitowoc County Sheriff to have become law enforcement target of choice. The police needed Bobby to testify against Mr. Avery to say that Ms. Halbach went to Mr. Avery's trailer, and Bobby needed to testify, exculpate himself, and inculpate Mr. Avery. Bobby seized every opportunity to frame Mr. Avery, including becoming the state's star witness. The state is incorrect that the evidence was difficult for law enforcement to detect, gather, and connect to Mr. Avery. The evidence was blatantly easy for law enforcement to detect immediately after it was planted, such as when Ms. Halbach's RAV4 was suddenly found coincidentally at the Avery salvage yard. Witnesses observed the vehicle in a different location earlier in the week, or Mr. Avery's blood was found significantly dripped in the RAV4 and replaced on the dash with the applicator. None of Mr. Avery's fingerprints were found on the RAV4, even though Mr. Avery could have crushed the vehicle in minutes. He allegedly left it in the plain sight of several days with the incriminating evidence intact. Only Bobby stayed behind when others leaving on the property went to the family residence in Crivets the weekend after Miss Halbach's disappearance. Thus, Bobby had an easy opportunity to plant evidence against Mr. Avery. Miss Halbach's key magically appeared on Mr. Avery's trailer after multiple searches had been made of his trailer without the key being detected. In response, completely devoid of the mention of the theory that during Mr. Avery's trial, the state's theory of what happened the day of Miss Halbach's murder left many questions unanswered. The state claimed that Mr. Avery unexpectedly placed Miss Halbach's body in the rear cargo area of the RAV4 in his garage, then removed her from the RAV4, laid her on the garage floor, and shot her in the left side of the back of the head. The state's nonsensical theory was contrived to explain that the presence of Miss Halbach's blood on the rear cargo door in the rear cargo area of the vehicle. The state did not have an explanation of how Miss Halbach's bones were found in multiple locations, which undoubtedly explained why Mr. Avery was acquitted of the mutilation charge. More likely, the chain of events with Miss Halbach had finished photographing Barb Yanna's van, and she was leaving the Avery salvage yard. Bobby followed her, flagged her down, and then attacked her. He placed her body in the back of the RAV4, drove back to the Avery salvage yard, drove into the garage. Yes, this is what I believe happened too. Drove into his garage, shot her in the head, dismembered her body, placed her in her body in the dashi burn barrels, transferred her to the quarry. He burned it, inadvertently spilling bones on the ground. And then when he brought the bones back to the Avery salvage yard, he tipped them into Mr. Avery's burn pit. That theory that Bobby returned to the Avery salvage yard with Miss Halbach in the cargo area of the vehicle is corroborated by the fact that the propane driver saw a vehicle similar to Miss Halbach's driving past him exiting the Avery salvage yard, and Blaine saw Bobby driving a greenish bluish colored vehicle on State Highway 147 in the opposition direction that Bobby testified he was driving. Both witnesses making these observations at around 3:30 p.m. on October 31st, 2005. The RAV4 was dumped about 1.8 miles west of the Avery property, where Kevin Ramlow spotted it on November 3rd. The state argues that Avery was offered no facts, that all was established that Bobby Dassey, an 8-year-old high school graduate with no criminal record whatsoever and who was working third shift at a furniture factory, could have executed the state's list of events that it argued that occurred in the murder of Miss Halbach. The state offered no facts to establish how Mr. Avery's high school dropout, whose experience consisted of serving 18 years in prison for a crime he did not commit, suddenly decided to murder Miss Halbach and forego the millions of dollars he stood to obtain from the state and civil rights lawsuit. Even if the court declined to believe the evidence offered as motive, the court must hold a hearing before making credibility determinations, stating that if the facts in the motion are assumed to be true, yet seem to questionable in their behaviorally, the circuit court must hold a hearing. Only after the evidentiary hearing is the court charged with determining the issues and making findings of fact, conclusions of law. The state claims that Mr. Avery had the burden of demonstrating the following points, which are contrary to Wisconsin case law, but regardless, Mr. Avery responds to each of the state's allegations concerning its claim that Avery had offered no facts at all would establish how Bobby Dassey, a 8-year-old high school graduate with no criminal record whatsoever, who was working third shift at a furniture factory, as follows: managed to steal in some unidentified time prior to October 1st and rifle hanging over Avery's bed, which the victim was shot, and at some other time, unidentified time before November 5th, managed to replace it with Avery's never noticing. Mr. Avery replied, the bullets from Mr. Avery's garage and the surrounding property were the result of target shooting around Mr. Avery's garage over a long period of time. All these bullets would have matched Mr. Avery's rifle. The bullet in Miss Halbach's DNA on it was planted by the killer. The bullet had the subsequent similar to red paint, like the red paint at Avery's garage, and never went through the skull of any other part of Miss Halbach's skeleton. The killer had access to Miss Halbach's DNA and could have easily planted in it on the bullet to Avery's garage. It's a little fun fact. I don't know how familiar you guys are with Stephen Avery's burn barrel, but it's got bullet holes in it. And if you listen to the jail calls, you can hear Jody talking about them standing by the garage and shooting at the burn barrel. And when you shoot a .22 caliber rifle, the bullets are going to be expelled out the right side. And if you're standing by the garage and facing towards where the burn barrel was, they're going to end up in the garage. But bullets from the neighbor's garage and surrounding property were result of target shooting. Okay. State response. Could have been abducted and killed the victim, hidden both her body and her car in some unknown area the minutes between her arrival on property and Scott Tatch passing Bobby Dassey on Highway around 3. Nor has Avery provided any facts to establish where the killing could have happened apart from a nondescript, or where Bobby could have hidden the RAV4 and the victim's remains in a short period of time. Mr. Avery's reply. Mr. Avery would challenge the credibility of Mr. Tadich and his timeline as an evidentiary. Mr. Tadich's testimony directly contradicts the testimony of Blaine, who saw Bobby drive in the opposite direction at 3:40. Mr. Tadich would be impeached on a number of other issues in the evidentiary hearing, including, but I'll limit it to his entire timeline for his whereabouts on October 31st, 2005, and his efforts to sell Bobby's .22 caliber rifle after the murder. State's response. 3. Had the significant sophistication and knowledge necessary for it to occur to Bobby to collect, transport, and plant Avery's blood from a sink, and as Avery has completely overlooked his non-blood touch DNA on the hood latch and victim's RAV4, and her keys are how Bobby acquired his skills to do this successfully. Mr. Avery's reply. Bobby could easily have removed blood from Mr. Avery's sink by using a wet sponge or rag or dripping it onto the RAV4, which was in his possession. He could have applied the blood smear on the dash with any type of Q-tip, like the object from the Avery's salvage yard. The touch DNA on the hood latch was planted by the police by substituting the groin swab illegally taken from Avery for the hood latch swab taken by investigator Hawkins. Even if that theory was discounted, Bobby had access to Mr. Avery's DNA and access to his trailer, so he could have used Mr. Avery's toothbrush. Well, now that we're talking about this toothbrush, Stephen Avery had a toothbrush holder on his sink. A few months after Jody is released from, after Stephen is arrested and Jody is released from prison, she's cleaning the bathroom and she finds his toothbrush underneath the sink and is asking him why it's there and how it got there. Even if that theory was discounted, Bobby had access to Mr. Avery's DNA. Bobby had access to his trailer. He also had access to Mr. Avery's toothbrush to plant his DNA on the hood latch. Bobby had to touch the hood latch to disconnect the battery. He would undoubtedly wear gloves, so perhaps the idea of planting Mr. Avery's DNA came to him as a result of the activity. Perhaps his 3 searches of DNA on his dad's computer gave him the idea. State's response. Had a convenient stash of unidentified instruments capable of collecting and transferring liquid blood on hand would have been. Mr. Avery's reply. The only instrument necessary to transport the blood would be a sponge or a rag, or a napkin or a paper towel. State's response. Planted the keys in the RAV4 in Avery's trailer unnoticed and at some specific time before November 3rd and November 5th. It also either managed to move the RAV4 off the 40-acre property without the keys or drive it away and return it on foot from wherever he supposedly took it, and then sneak it into Avery's trailer again to hide the keys at some of the unidentified time, once again unnoticed. Mr. Avery's reply. Bobby had the vehicle key when he drove the RAV4 to his location at the State Highway 47, Monday, October 31st, and on Friday, November 4th. When he moved it back onto the Avery salvage yard, he planted the key in Mr. Avery's bedroom after removing Miss Hallbach's DNA from it and putting Mr. Avery's DNA on it. Many items in Mr. Avery's trailer could have been the source of the DNA, including Mr. Avery's toothbrush. The key was not discovered until November 8th. Bobby was alone on the property after the family left on November 4th and early on November 5th until police blocked off access to the property when Miss Hallbach's vehicle was discovered around noon. All the family members residing on the Avery property had left and traveled to Crivets to the family residence. State's response. Found and then planted a tiny mangled bullet fragment that Bobby unexpectedly knew that the victim's DNA underneath the items in the Avery garage or ultimately how he shot the victim in Avery's garage on October 31st, and then another unidentified time scrubbed the scene with Avery remaining unaware despite Avery undisputedly having been working on the Suzuki and other vehicles and around the garage around this time. Thing about the Suzuki, he didn't bring that home until the 30th of October, the day before this happened. He brought it home with Earl. Earl put it on the flatbed. Stephen drove his truck up north with his snowmobile trailer and placed the snowmobile on his trailer. You can hear him in the jail call on the 30th talking about doing this. He also talks about the brush that Redant wants him to burn. There's also photos from Cuss Road, Wisconsin State Patrol, that still shows a pile of brush still left in the field because Stephen didn't get to burn it. Found and planted tiny. Okay. Mr. Avery's replied, Bobby had access to Miss Halbach's blood if he killed her and could simply put the blood on one of the dozens of bullets in and around Mr. Avery's garage. There's no proof that Miss Halbach was shot in Mr. Avery's garage. There's no other DNA of Miss Halbach's in Mr. Avery's garage. There's no blood spattered in Mr. Avery's garage or Mr. Avery's rifle. There's no evidence that the crime occurred in Mr. Avery's garage. Burn the victim's body in some undisclosed location and then remove the remains to Avery's burn pit. Again, completely undetected and did not so thoroughly as to include that at least a fragment or more of almost every bone below the neck and the entire human skeleton along with the rivets from her jeans, nor has Avery provided any facts showing where and when this occurred. Mr. Avery's replied, Mr. Avery was acquitted of burning Miss Halbach's body. Miss Halbach's body was not burned in Mr. Avery's burn pit, but was burned in the Dassey burn barrel, which contained Miss Halbach's bone fragments, which had cut marks and smelled of flammable liquid. Halbach's bones were ever discovered, and her bone fragments were found in the quarry, suggesting that she was burned in the Dassey burn barrel in the quarry, transported back to the Avery salvage yard, where the bones were dumped in Avery's burn pit. Affidavit of John D. Hahn. Convinced his younger brother Brendan to go along with his plan to fabricate and confess implicating himself in Avery, or why Brendan would do so. Mr. Avery's reply, it was not Bobby who coached Brendan, it was the police. As Brendan's interrogation video indicates, the paragraph 4, which would leave 26 minutes and 24 seconds to plant Mr. Avery's blood. Additionally, Bobby could have used the water-infused sponge to collect the blood from Mr. Avery's sink, which would have slowed the coagulation process without affecting the DNA profile of Mr. Avery. The internet search for blood on Dassey's computer could have revealed that addition of water blood slows and stops the coagulation process. If the defense theory in a third-party frame, the defense might show by demonstrating the third party's access to the items supposedly used in this frame-up. To all forensic evidence, and therefore had an opportunity to frame Mr. Avery. Moreover, the defendant need not establish the guilt of the third party to the level that would necessary to sustain the conviction to the third party perpetrator evidence. The supportive deduction of such evidence must be legitimate tendency that this court cannot determine the new evidence regarding Bobby being in possession of Ms. Halbach's car and moving it out to the Avery salvage yard in the middle of the night without holding an evidentiary hearing to determine the credibility of the new eyewitnesses. Sowinski, no matter what versions the state attempts to concoct on suppositions, arguments, and raises, that issue this cannot be resolved without an evidentiary hearing which necessitates credibility findings by this court. The state's direct connection and argument. The court must determine first whether the motion faces alleged sufficient material facts that, if true, would entitle the defendant to relief. The state, rather than accepting Mr. Avery's material facts as true, is attempting to dispute those facts with speculative theories unsupported by the record. By disputing rather than accepting Mr. Avery's facts as true, the state is conceding that Mr. Avery is entitled to an evidentiary hearing to resolve those disputes. As an example, the state concedes the necessity of the evidentiary hearing in its footnote by attempting to claim that Sowinski's admissions have changed drastically. The state is attempting to perform its own credibility analysis of Sowinski, which is totally improper at a pleading stage where the allegations must be taken as true. In briefly addressing the issues of Bobby's direct connection, the state argued Sowinski's arraignments that purportedly saw Bobby pushing around 400-member fists several days after Ms. Halbach's murder did not provide a direct connection between Bobby and Dassey. However, corroborated evidence that Lewinsky provided does precise action of the victim's vehicle. Officer withdraws reasonable inference that both Williams and Armstead possession of the brown stolen car. There was probable cause to believe that both Williams and Armstead probably had committed a crime involving the murder's victim's stolen car. Applying this rationale, the Lewinsky evidence provides a direct connection with that is Bobby being witnessed in possession of Ms. Halbach's vehicle to Bobby probably having committed the murder of Ms. Halbach. The defendant argued that the affidavits attempted to implicate her, the ex-husband's killer, were newly discovered evidence. However, the appellate court found that the affidavits were not newly discovered evidence, but were merely cumulative evidence introduced in the trial. There were already evidence introduced in the trial that the victim was afraid of the third party. None of the affidavits established the third party was directly connected to the crime. But Bennett is a completely incompetent Lewinsky evidence in Mr. Avery's case. The new evidence presented to Mr. Avery is not cumulative or evidence presented by Mr. Avery's trial. None of the evidence provided by Lewinsky directly connecting Bobby to the actual murder of Ms. Halbach, and the opportunity to plant forensic evidence to frame Mr. Avery was known during any prior proceedings in this case. Lewinsky's evidence is newly discovered, unavailable, and not discoverable through reasonable diligence at the time of Mr. Avery's June 2017 motion. Lewinsky's existence information was not known and discoverable by current counsel, so Lewinsky contacted counsel on April 11, 2021. Additionally, the states overlooked the fact that possession of the evidence used in the frame of the defendant also qualifies as making someone a third party. The state attempting to impose a burden previously rejected by Wisconsin Supreme Court in Denny's decision. The state is requiring the evidence of connecting the third party to the crime by substantial. Wisconsin rejected the standard in State versus Wilson. State waived its Econia Naranjo procedural bar. The appellate court specifically directed Mr. Avery to file his motion pertaining to the new evidence from Lewinsky and specifically state that evidence needed to survive any State versus Econia Naranjo, blah, blah, blah. Challenge. The perplexity of the state is waived Esconia challenged by not raising it. Therefore, the state conceded Esconia and not barred Mr. Avery's new motion. Mr. Avery provided sufficient reason for overcoming the bar in the third motion of post-conviction relief. Mr. Avery entitled to evidence hearing on his newly discovered evidence claim. Defendants must meet a 5-part test to obtain a new trial based on newly discovered evidence. When moving for a new trial based on the allegation of newly discovered evidence, a defendant must prove 1. Evidence was discovered after conviction, which he did. The defendant was non-eligible in seeking evidence, which he was. 3. The evidence is material to an issue that in the case, and it is, and the evidence is not really cumulative. Definitely not. If the defendant is able to prove all 4 of these criteria, then it must be determined whether a responsibility probably exists, and the jury heard newly discovered evidence, it would have had a reasonable doubt as to the defendant's guilt. Well, the fact that the jury requested to look at Bobby Dassey's testimony one more time, and the judge denied it. And the VCD wasn't turned over until after his trial, and then the Ramlo coming forward, and now Lewinsky. He's got way more violations than he needs to get to evidentiary hearing or in a trial. As stated above, Mr. Avery was sufficiently established opportunity, motive, and direct connection to Bobby and the crime. There is reasonable possibility of different results in a new trial. The state argues that even if Mr. Avery has presented newly discovered evidence at least satisfying the first 4 group prongs of the newly discovered evidence test, he cannot show that the evidence was the cause of the jury to have reasonably done. How can the state of Wisconsin determine what a jury would decide when they're not on the jury? First, the state contends that because Mr. Avery did not plead sufficient facts to establish Denny, his allegations would be inadmissible at trial, and thus he is entitled to evidentiary hearing on his newly discovered evidence. However, as already argued above, Mr. Avery has pled sufficient facts to establish Denny. Therefore, the state's argument fails. Second, it argues that even if Lewinsky evidence was admitted and Mr. Avery's theory of defense were presented, there is no reasonable probability of different result in a new trial. As explained above, there are far too many considerable inconsistencies between Avery's allegations about Bobby Dassey and the actual evidence produced at trial. Particularly damning would be Avery's complete failure to account for the DNA on the hood latch of the RAV4. Ms. Halbach's remains again, including a fragment from virtually every bone in the human body being found in the burn pit, and nothing explaining why Bobby would possibly be responsible for the bullet with Ms. Halbach's DNA being found in the garage. Mr. Avery addressed DNA on the hood latch and garage of Miss Halbach's bone fragments in his burn pit. The state needs to be reminded that Mr. Avery was explaining how Bobby could easily be responsible for the bullet with Miss Halbach's DNA planted in Mr. Avery's garage that matched his gun. Miss Halbach's DNA in the RAV4 and spent bullets from Mr. Avery's rifle in his garage and property were easily accessible for Bobby. Well, let me stop right here. The day that Brendan Dassey is re-interviewed on March 1st, we got Wendy Baldwin going from the Hickory Hill storage to the Avery property while this interview is going on before they get the search warrants. And while they're interviewing Brendan, Pagel, Hawkins, Tyson, they're all at Hickory Hill storage going over the evidence. The state claimed, that's why Uyghur keeps getting phone calls. Enormous amount of forensic evidence pointing directly to Avery as the killer were all far more material than Bobby. The state misses and marked entirely if Bobby transforms into a viable third party, any suspect, because the Lewinsky evidence is found to be credible after the evidentiary hearing. All the forensic evidence used to convict Mr. Avery is now placed in Bobby's hands. He is no longer facing a jury. As a disinterested impeached witness, the state has not presented a shred of evidence that Bobby did not commit this crime, such as the alibi, particularly in the light of possession of Miss Halbach's blood-splattered vehicle directly connecting him to the actual murder, his opportunity to plant all the forensic evidence and motive established in the pornographic searches on the Dash computer located in his bedroom. The state versus Wilson held the constitutional and refused to allow the defendant to present the defense simply because the evidence against him was overwhelming. Mr. Avery would be able to present the theory that all evidence against him was planted by that Bobby is viable third-party suspect and reasonable probability of difference results in a new trial. Mr. Avery pledged sufficient facts to establish a violation of Brady versus Maryland. Mr. Avery provided sufficient facts to establish audio clips materially. In addressing Brady claim, the court is not to view a piece of suppressed evidence in isolation. Instead, the court is required to access the cumulative impact of all suppressed evidence to determine its materiality. Suppressed evidence is material if its cumulative effects creates a reasonable probability of a different result. A reasonable probability of a different result exists if the suppressed information undermines confidence in the verdict. A reasonable probability is lower the procedure proponent with evidence standard. It is demonstrated that the defense shows that the failure undermined confidence in the conviction, Youngblood versus West Virginia. State claims Avery dodgy and consistent insistence that Bobby Dassey was the state's primary witness against Mr. Avery at trial remains false no matter how many times he repeats it. Bobby established only that Miss Halbach arrived at the Avery salvage yard on the day in question, and he saw Miss Halbach walking toward Mr. Avery's trailer shortly before she disappeared. Bobby was the state primary witness against Mr. Avery during its closing argument, with prosecutor Ken Kratz once again emphasized the importance of Bobby Dassey's testimony and vouched for his credibility. We talked more about the timeline and learned that Bobby Dassey again in the same kind of position to be, his credibility to be weighed by you, but it's in eyewitnesses again, eyewitnesses without any bias. Is it an individual that deserves to be given a lot of credit because sometimes between 2:30 and 2:45 he sees First Halbach, he sees her taking photographs, he sees her finishing the photo shoot, he sees her walking up towards Uncle Steve's trailer. Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Ms. Halbach never left the Avery property alive. If the jury knew that Bobby was lying about seeing Ms. Halbach leave the property because he was in possession of a blood-splattered vehicle and moved it back onto the Avery property, then the defense could have argued that Bobby was directly connected to the actual murder of Ms. Halbach and planted forensic evidence to frame Mr. Avery with a viable third-party Denny Sussman was directly connected to Ms. Halbach's murder and planting the forensic evidence to convict Mr. Avery. Confidence in the verdict would be undermined. There is no more sufficient evidence to conclude that Bobby actually committed this crime. There is no reason for him to have told multiple lies that he's told in the case, so he's culpability. There's no reason for him to have possession of the victim's blood-splattered vehicle to planted on the Avery property. There's no reason for him to have unexplained scratches on his back where the victim's cut, fueled, stained bones, and Dassey burn barrel. Bobby was the only family member to stay on the property after the others had left. Mr. Avery's Brady claim regarding Kevin Ramlow has not been litigated. The state incorrectly claims that Brady issue regarding Ramlow seeing the RAV4 was was already litigated in the appellate court, July 2021 opinion. The appellate court noted that Mr. Avery's motion for reconsideration raised an issue pertaining to the witness affidavit attesting in 2005 a witness, Ramlow, observed a vehicle matching in person's poster of a Hallbox car, informed law enforcement of the fact that the state withheld evidence that the Hallbox vehicle was seen on the streets the day after his disappearance. The appellate court declined ruling on this issue. Therefore, it was never litigated. Specifically, the court never stated the following: neither we nor the circuit court have squarely considered whether these claims are procedurally barred under Estonian Arrow, and whether Avery pled sufficient material facts entitling him to a hearing, though the analysis overlaps with the former inquiry. Such consideration would have to come on a separately filed Wisconsin 97406 motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed. Mr. Avery could not have discovered the existence of Ramos through reasonable diligence because there is no mention of him in any police report or prior defense counsel file. It would have been impossible for Mr. Avery to discover the evidence. Only after Mr. Avery filed a 2017 motion, the witness came forward. The record does not consistently demonstrate that Avery could not establish a right violation at a hearing. The state claims were not previously litigated and would fail because the record consistently demonstrates that Ramlow says in an affidavit about telling Sergeant Colborn on November 4th that he saw the victims on RAV4 highway cannot possibly be true. The state proceeds to dispute Colborn's schedule, which is an improper attempt to litigate a witness' credibility, and the pleadings Ramlow's credibility must be subject for an evidentiary hearing. Regarding Sawinski's evidence, the state deliberately conflates the snippet of audio that Mr. Avery discovered with the information Mr. Sawinski provided police that is biased to the Brady claim. Mr. Avery does not have to present any audio, including the snippet of the audio alleged Brady violation. In fact, the significance of the audio that is corroborates the fact that Sawinski provided exculpatory information to the Manitowoc Sheriff's Department that was supposed to be suppressed by the state. Sawinski could simply testify he reported this occurrence to law enforcement, and if this court finds it credible and sufficient to establish Brady violation. The state claimed that the audio clip transcript undermines the veracity of Mr. Avery's claim is nonsensical because the court can listen to the audio clip without looking at the translation provided by Mr. Avery. The audio clip from Manitowoc Sheriff's Office speaks for itself. Further, in regard to the footnote 10 of the state's response, Mr. Avery is not obligated to have affidavit from Sergeant Sunglob or any investigator in the Manitowoc Sheriff's Office who spoke with Sawinski on the phone. It is sufficient that Sawinski would testify that he made the call to the Manitowoc Sheriff's Office, and it is up to the court to determine his credibility. The audio clip simply provides some corroboration of Sawinski's witness affidavit. Mr. Avery has satisfied the Allen requirements for an evidentiary hearing. In court, Allen determined that the motion contains sufficient material facts for the evidentiary hearing, and it includes the name of the witness, reason the witness is important, why, how, and facts, and proven what, where, when. They clearly satisfy the Bentley standard and would entitle the defendant to a hearing. As the chart illustrates, Mr. Avery has met all Allen requirements: who, what, where, when, and why. Who? Thomas Sawinski observed Bobby Dassey pushing the RAV4. What? Sawinski was delivering papers on the Avery'S salvage yard. Early morning hours of Saturday, November 5th, 2005, he observed Bobby Dassey and an unidentified male were pushing a Hallbox vehicle down Avery Road on the right side towards the salvage yard. Where? The salvage yard. When? Early morning hours of November 5th, 2005, the same day this Hallbox vehicle was discovered by law enforcement after the civilian search discovered the vehicle on the Avery salvage yard. Why? This new evidence disclosed to Mr. Avery directly connects Bobby Dassey to the actual murder of Ms. Hallbach, as well as having the opportunity to murder Ms. Hallbach and plant the forensic evidence used to convict Mr. Avery. Sawinski reported his Manitowoc Sheriff's Office. Manitowoc Sheriff's Office prosecutors failed to disclose the information to Mr. Avery's trial attorneys. As with any other civil pleading, assessing the legal sufficiency of the motion, the court must assume that the facts alleged therein to be true, even if the court declined to believe the evidence offered by the motivant. The court must hold a hearing before making credibility determinations. Only after evidentiary hearing is the court charged with determining the issue and making findings of fact and conclusions of law. Conclusion: Mr. Avery respectfully requests that the court grant him one of the following alternative remedies. 1. Grant the evidentiary hearing. 2. Grant the amended motion for post-conviction relief by ordering a new trial. And 3. grant and request relief and grant any and all relief this court deems appropriate. Dated this date 26th of January 2023. Again, Judge Sucketis has no time to respond, no time limit. So I don't know. I know what she should do. She should grant the evidentiary hearing for one, but she's got people telling her what to do. I mean, the fact that the state intervened trying to tell her to deny the motion after this appellate court gave the owner a blueprint to follow when she refiles. So, and another thing, there's new judges in the Court of Appeals. So we might have some luck going back to the appeals if that's where it in fact goes. But yeah,